Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and today I'm going to take you on a little journey through Chapter 7 Bankruptcy. We're going to go from the beginning to the end, let you know what happens all in between, and maybe alleviate some of those fears you have if you're facing Chapter 7 Bankruptcy. But if this is your first time here to my YouTube channel, please click subscribe. I put out new videos each and every week to help you deal with your serious debt problem. All right, let's talk about Chapter 7 Bankruptcy. Now, if someone is looking to file bankruptcy, there is Chapter 13 and Chapter 7. Overwhelmingly, people file Chapter 7. That's what I want to talk about today. I want to give you an overview of what that process is. I know a lot of the anxiety comes from the uncertainty and really the unknown of what happens during a bankruptcy process. And so I want to let you know kind of what to expect from it. Now, it does vary a little bit from state to state, but the Bankruptcy Code is a federal statute, and so a lot of it is the same from state to state as well. So the first thing that happens is you meet with your bankruptcy attorney, like me, if you're in the state of Arizona. We talk and we just really kind of determine if it's a good fit. We look at your income, we look at your assets, we look at the amount of unsecured debt you have, like credit cards, medical bills, personal loans. We look to see if you have secured debts like home loans, car loans. We look at things like taxes, student loans, and we try to determine if you have any assets that are at risk of being lost if you file Chapter 7 bankruptcy. Now, the idea behind a Chapter 7 bankruptcy, it's going to get rid of all of your unsecured debt. Credit cards, medical bills, personal loans. With the exception of most taxes and student loans, all other unsecured debts generally go away. However, the court's going to look and say, hey, okay, we got rid of that debt. The trade-off is we're going to look to see, are there any assets that the court can seize, sell, and give the money to your creditors? And so we go through all of that to see if you're at risk of having any of those taken. Now, luckily, there is what are called exemption laws. Each state has them. The federal government has them. They protect things like, the homestead exemption can protect equity in your home, equity in cars, household goods. There's 401ks, IRAs, retirement accounts, things like that. Most things are protected, and I can tell you most people don't lose anything as they go through this process. So the next step is we look to see if you qualify. There's something called the means test that you have to meet if you're going to file a Chapter 7 bankruptcy. They base that upon the number of people in your household and your total household income on a monthly basis. Now, the way that that's calculated, we look back 6 months and take an average of your total income for the household and then compare that with the numbers that the federal government provides. And those are based state to state and even sometimes county to county in different jurisdictions. So that's something you're going to have to meet with the bankruptcy attorney in your state, because those numbers are updated periodically to be able to show what you have to make or what you have to be at or below to be able to qualify. One little caveat to that, it's important to know if you look online and you see that your income is above the means test, you still may be able to qualify because there are various deductions, things like house payments, car payments, taxes, child support, alimony, all those kinds of things can be deducted. And so if you're not a whole lot above it, you may still be able to qualify. It's definitely worth talking to a bankruptcy attorney to get an idea if you find yourself slightly above it. One thing that's important to know with the means test is that they do not count Social Security or VA disability in those calculations. So if you have income that is based upon those two areas, you don't take that into consideration when determining if you qualify for a Chapter 7 bankruptcy. So once we determine that you are ready to go, that is something that you can do, we then start preparing what's called the Voluntary Petition and then the schedules and statements. The Voluntary Petition has just general information like name, address, Social Security number, that kind of stuff. The schedules and statements are going to break down the things like assets, income, monthly expenses, financial transactions. All of that's going to be laid out. It's incredibly long, and it seems like every year they add more requirements. When I first started filing bankruptcies, I think I filed my first one in 2003, 2004. The bankruptcy documents were about 45 pages long. They are close to 90 pages long. They keep adding more and more requirements. So that's just something to be aware of. There's a lot of information that you're going to have to provide your attorney. You are also required, before the bankruptcy is filed, to complete an online credit counseling course. This online credit counseling course is just an informational thing. They do ask you questions, but it's not something to stress out about. It's about a 1-hour thing. You do it online. It's a video. And at the end, I get a certificate that says they did it. That's the extent of it. It's not something you need to worry about. It's not something where your answers go to the court or anything like that. It's just an informational video to help you with financial management. Once we're ready to go with the documents, credit counseling's done, we file the case with the court. Immediately, the court puts an order in place that stops all collections. This stops wage garnishments, telephone calls, snotty letters, all of that kind of stuff stops completely once we file the Chapter 7 bankruptcy. Those documents are then uploaded to the court. Everything's done electronically with the bankruptcy court. And about a month to 5 weeks later, there will be a meeting with a bankruptcy trustee. Every Chapter 7 case is assigned a bankruptcy trustee. Their job is to oversee the case, to see if there's any assets that are to be liquidated, and to work with creditors if there is assets where money's going to be distributed. They take care of all that. This meeting that happens about 4 to 6 weeks after the bankruptcy case is filed, it's called the meeting of the creditors. It's a little bit of a misnomer because it's generally a meeting with you, your attorney, and the bankruptcy trustee. Now, ever since COVID-19, they have changed it, and these meetings are no longer done at the courthouse, but they are done telephonically or they're done through like a Zoom type call. Makes it really convenient, especially because the meetings are not that long. It's literally about a 5-minute meeting. They put you under oath. They ask you if the information that you submitted to the court is accurate. They're going to ask you if you listed all your creditors, if you listed all your debts. They're going to ask you if you've lived in the state like of Arizona for 2 years, if you live in Arizona, and they'll ask you if you filed any prior bankruptcy cases in the last 8 years. Now, after the meeting of creditors, in most cases, as far as you're concerned, that's really it. You are required to do one other financial management course. Again, it's a video that you watch online. It takes about an hour, hour and a half. But as far as your part of it, it's really done. Then the trustee is just going to look to see, again, if there's anything that can be distributed. If not, they'll push the case down the line. And after certain deadlines expire, the clerk of the court will then issue a discharge order. This discharge order is an order signed by your judge, and this is the whole reason why you filed a Chapter 7 bankruptcy, is to get this discharge order from the court that says that you are no longer legally obligated on certain debts. Now, it's important to note that is generally not it for the case completely, because even though the case has been discharged, the case is still open with the bankruptcy court. If the bankruptcy trustee is still trying to determine if there's assets that can be liquidated, sometimes they're going to wait for a tax return and a tax refund from the following year to be submitted. They'll leave the case open until those things take place, and then once they are done, the court will administratively close out your case. I can tell you right now, state of Arizona, the typical Chapter 7 case takes about 4 to 5 months to run the entire course. So, I hope that's helpful. If you are thinking of filing for bankruptcy and you're in the state of Arizona, my contact information is below. I'm happy to do a free consultation to help you determine if this is a good option for you and evaluate if there's any risks or pros and cons, that kind of thing, and make sure that you're making a sound financial decision. Thanks for watching today.